Good afternoon. My name is Micah Watson. I have the privilege of directing the Paul B. Henry Institute for the Study of Christianity and Politics. And on behalf of myself and my colleagues Joel Westra and Mark Hessler, Director and Associate Director of Calvin's Pre-Law Program, respectively, we welcome you to this afternoon's Constitution Day event. On September 17th, 1787, members of the Constitutional Convention signed the Constitution, thus initiating the ratification process. In 1956, Congress established Constitution Week to begin each year on September 17th. By the way, this year, September 17th is on a Saturday, hence our flexibility with today's date. In 2004, West Virginia Senator Robert Byrd included provisions in the Consolidated Appropriations Act of fiscal year 2005. I'm guessing most of you have not browsed through. Me neither. He put in there a provision designating September 17th as Constitution Day and requiring public schools, government offices, and any educational institutions receiving federal funding to somehow recognize and commemorate Constitution Day. That requiring language may sound odd to you. We might think that institutes of higher learning, like Calvin University, like the University of Notre Dame, would host events about the Constitution just for the intrinsic good of learning itself. But Senator Byrd's requiring language reflects perhaps an insight about human nature, even we might say a Calvinist insight about human nature, that human beings cannot always be depended on just good intentions to do the right thing. To paraphrase another Virginian, dependence on the good intentions of colleges and universities is no doubt primary, but experience has taught mankind the necessity of auxiliary precautions. And so here we are. I'm delighted to introduce our speaker to you this afternoon. Sharif Girgis comes to us from the University of Notre Dame School of Law, which he joined in 2021 as an associate professor. He has an undergraduate degree from Princeton University, was a Rhodes Scholar, earning a philosophy degree in 2010, a graduate of Yale Law School, and currently finishing his PhD in philosophy, also from Princeton. It's been productive. He's author of several articles and book chapters in both the areas of jurisprudence, as well as philosophy, as well as the intersection of both of those fields. He served as a law clerk for Judge Thomas Griffith at the U.S. Court of Appeals for the D.C. Circuit, as well as for Justice Samuel Alito at the United States Supreme Court. He's a member of the bar in the District of Columbia and now makes his home roughly 2 hours south of us in South Bend with his wife, Gabby Girgis, herself a Notre Dame alumnus, holder of a doctorate in politics, also from Princeton University, and a teaching fellow at Notre Dame Center for Citizenship and Constitutional Government. The conversation around the kitchen table at their household, I'm guessing, is pretty robust at times. Professor and Dr. Girgis have 2 young girls and are expecting to welcome a son within the next couple of weeks. Would you please join me in welcoming Sharif Girgis to Calvin?
Thank you very much, Professor Watson, for bringing me here. I'm a huge fan of his and was very happy to do anything he asked, and thanks to all of you for coming. I wanted to make this exciting because I know that not everybody in a college and an undergraduate setting knows a ton about the Constitution. So my big headliner question for the lecture is whether we are living through one of the most important constitutional moments in our history. A lot of people would say that at least until this summer, the most important constitutional decision of the last 50 years was Roe v. Wade, which recognized a constitutional right to abortions up to the point of fetal viability. The question is whether Dobbs v. Jackson Women's Health Organization, which overturned Roe this summer, is going to have a similarly deep and ramifying and lasting impact on our constitutional law and culture. So a lot of the not only pro-life but also pro-choice legal commentators and scholars at the time and since thought that Roe v. Wade, whatever you think of abortion policy, had some negative effects on the law and culture surrounding the Constitution more generally. And it was the promise of the conservative legal movement for about 40 years that overturning Roe would undo some of those supposed harms. But since Roe was overturned a few months ago, there hasn't been a lot of talk about whether we can really expect those gains to happen. And to the extent that there has been, the jaundiced, sophisticated view has been, no, it's too late, the damage has been done. And I want to just explore that a little bit. So I'll talk about 7 possible effects of Roe v. Wade on our law and culture, and what the early evidence might suggest about whether Dobbs has any chance of undoing any of them. And to tease the outcome, my conclusion will be it's not as bad as it looks, that there is some reason to think that at least some of those effects might begin to unwind with Dobbs. The first effect that a lot of people point to of Roe v. Wade is that it polarized the issue of abortion. It polarized Americans on abortion. A lot of people point to the fact that in the lead up to Roe, there was beginning to be a bit of liberalization and moving towards the middle on abortion policy, that in Western Europe, where abortion policy is decided by the people and their representatives and not by the courts, most countries have converged on some kind of middle ground, usually regulations from the first trimester, from the first trimester onward. But in the US, the advent of Roe itself polarized the country. And it's not hard to see why. So to give you a sense of what Roe itself held, consider the law that was at issue in Dobbs itself, which is a 15-week abortion law in Mississippi, bans most abortions from 15 weeks of gestation onward. That law already is more liberal than the abortion laws of almost all industrialized countries. In fact, there are only 12 or so countries that have more liberal abortion laws, or as liberal abortion laws, and those include China, North Korea, and Vietnam, and others that have a mixed bag on human rights. As I mentioned, in Europe, most countries hover somewhere around regulations being permitted from the first trimester onward, but Roe not only would have deemed the Mississippi law unconstitutional, but would deem any law unconstitutional that regulates abortion at all up to 23 weeks. Or 24 weeks, whenever a doctor certifies that the fetus has reached the point of viability, the ability to live on his or her own outside the womb. As a result, it became practically impossible for politicians to pass meaningful abortion regulations, which meant that politicians on both sides faced the question only of thumbs up or thumbs down on Roe. No one had to pay the price for actually proposing a concrete but extreme policy, and no one had to pay the price for voting down a moderate policy. So the two sides polarized around the issue in that way. They didn't just polarize. The decision itself and the way that it was done tended to shape the judiciary. It shaped the judiciary in one respect, and this is my second effect of Roe, by, for lack of a better word, moralizing it. Moralizing the judiciary in the sense of introducing into our constitutional law and reasoning, nakedly moral reasoning about the pros and cons of different policy outcomes. What do I mean? Well, in general, in legal disputes, you want to be able to cite a legal source for your argument. But Roe v. Wade, though it based the right to an abortion in the Constitution, did not quote the legal text the constitutional text at any point. In fact, it didn't even settle on exactly which text it thought the right was rooted in. It talked about precedents to some extent, but Roe itself admitted that those precedents recognized rights that were, quote, inherently different from the right to an abortion. And it talked about history to some extent, but it actually talked about the history of non-US jurisdictions, including ancient Rome and Babylon and Egypt and so on. And when it did talk about American history, it ended up creating a legal rule that was quite different from the rules that it itself identified as rooted in our history. So if it didn't talk about text, or if it didn't root the right in text or history or precedent, what did it base it on? It based it on a pure moral analysis. When push comes to shove, if you look at the opinion, Justice Blackmun, writing for the court, says that women need to have a right to abort up until the point of viability, because until then, the woman's interest in autonomy and in the bodily integrity and privacy outweighs the interest in protecting fetal life. And after that, the interest in fetal life is strong enough that states can legitimately ban abortion. So it's a pure weighing of moral goods and harms without any reference or rooting in the text or history or precedent of the Constitution. That kind of pure moral analysis, it's not absolutely brand new to the court, to this context, but I think that Roe v. Wade arguably cemented that pattern of reasoning. So while there were other moral balancing tests in other areas of the law, they began to proliferate. in all kinds of contexts. In the free exercise clause context, over the next few decades, the Supreme Court said whether you have a right to an exemption to protect your religious activity from an otherwise neutral regulation depends on a weighing of the cost to you of the burden imposed by the law and the cost to the government of giving you an exemption. Even in really mundane contexts, set aside individual rights and liberties. In contexts like federalism, like the rules governing when a state can ban the shipment of goods or services into its borders. The court, which seems to put a burden on federalism to the extent that it limits interstate commerce, allows one state to exert some force on other states. The court said that the test for whether those regulations are okay, it requires you to directly balance the weight of the benefit to the local government of that regulation against the weight of the harm to interstate commerce. A lot of these cases involve, or seem to involve, the weighing of apples and oranges, of incommensurable goods and bads. Justice Scalia, in an opinion lampooning some of these tests, said, it's like asking me whether a particular rock is heavier than a particular line is long. It's just an impossible calculation to do, but it's the kind of calculation that Roe, if it didn't quite inaugurate it, it did cement it as a pattern in our constitutional reasoning, and it shows up again in many areas of the law. So it polarized the abortion issue, it moralized the judiciary, it also politicized the judiciary. Just as it brought moral forms of reasoning into our politics, the kinds of reasoning that are centrally at stake in political debates, so it brought more and more political debates into the judiciary. Abortion itself wasn't just a one and done deal as far as the Supreme Court was concerned. It was there in 1973 in Roe versus Wade. It was also there in 1978, in 1979, and 1980, 1983, 86, 88, 89, 90, 92, 97, 2000, 2007, 2016, and 2020. And then, of course, again, in 2022, I'm probably missing some, but that already is an average of about one every 3 years for a 50-year period. Plenty of other issues that we could discuss as examples of what seem to be paradigmatically political issues without an obvious constraint one way or the other in constitutional text or history that become judicial battles. Affirmative action. Affirmative action is a case that the Supreme Court first deals with in 1978 and then deals with about a dozen times after that over the next 30 to 40 years. Issues surrounding executive power, so a kind of micromanaging of the executive and every major, including signature policies of different administrations. So probably the most salient example is the Affordable Care Act, Obamacare. This was a law that was obviously vigorously disputed in the political branches, but as soon as the Republicans lost the battle in Congress, they immediately took to the courts. There were 2,000 state and federal challenges filed in different courts across the country to Obamacare. They coalesced and converged and culminated in 3 major Supreme Court cases in 2012, 2015, 2021. It's not just the range and number of the political disputes that got to the court as the court became more involved in these issues. It's also the degree to which they were micromanaged by the court. So to give you just a few examples, in the affirmative action context, within just a few month period, the Supreme Court in one case said that the University of Michigan's affirmative action policy for undergraduate admissions was unconstitutional, but that the same university's affirmative action policy for law schools was constitutional. In cases like the Establishment Clause, cases where the court is trying to figure out whether a religious display on public property counts as an establishment of religion, the court on the same day in June of 2005 says that a display of the 10 Commandments in a Texas public park is constitutional, but a display of the same 10 Commandments in a Kentucky courthouse is unconstitutional because of the setting and the sizes and the number of other images surrounding them in each case. There's a micromanaging of the executive. Every major executive action or policy decision immediately comes under attack. So when the Obama administration enacted DACA, the Deferred Action I'm losing the rest of the acronym now, the Dreamers Act. So the executive decision that basically said that people who came as undocumented immigrants when they were minors will have a path to avoiding deportation and getting work permits. When DACA was instituted by the Obama administration, it was challenged. When it was rescinded by the Trump administration, it was challenged. When Trump enacted his own border policies, Remain in Mexico policy, it was challenged. When the Biden administration attempted to rescind Trump's Remain in Mexico policy, it was challenged. Trump's policies on adding a citizenship question to the census, his so-called travel ban, all of those were challenged. The Biden administration's many attempts to deal with COVID in several different ways were challenged. A mask mandate, a vaccine mandate, a moratorium on evictions by landlords. Professor Steve Vladeck of the University of Texas at Austin has done some number crunching on these kinds of things, and he showed that in a 3.5-year period during the Trump administration, the administration went to the Supreme Court seeking emergency relief from a lower court decision attempting usually to strike down one of its policies 36 times, which turns out to be more than double the number of times that previous administrations had done that in 16 years combined. And the trend is more or less continuing from there. So even though it's never been the case that the court is completely apolitical, I think there is a clear trend over the last few decades of it reaching a wider range of political disputes without any clear connection to the Constitution, increasingly micromanaging those disputes, and then being the final arbiter on of the major policy initiatives of different administrations. So the abortion issue was polarized, the judiciary was moralized, the judiciary was politicized, and our politics were judicialized, if I can get away with that. By which I mean that the more our political debates moved into the courts, the more our political battles, elections, became about the courts. Because after all, the politicians, at least the Senate, who have to consent to any appointments to the court by the president, became more and more just about the selection of the people who would be making policy for us, namely the judges, and who would be able to make policy without being checked by a re-election campaign. To give you a sense of how different things are now from how they were before Roe and originalism were center stage, Justice Scalia's nomination in 1986, which was at a point in the court's composition where there was no suggestion that Roe hung in the balance. And the originalist and conservative legal movement more generally were not big deals at the time. They were really just getting going. In 1986, Scalia, the lion of the conservative legal movement, was confirmed to the court by a 98-0 vote. But it was shortly after that Robert Bork's nomination by President Reagan seemed to potentially put Roe in the balance. And Senator Kennedy took to the podium and said, in Robert Bork's America, women will be forced to back alley abortions and so on. Bork's nomination went down in flames just a year or two after Scalia's was unanimously confirmed. Almost every other major hardball politics moment in the confirmation battles can be attributed to Roe. When the Republicans sit on the Garland nomination for a year so that in the hopes that President Trump would be able to replace, to fill the seat, that was about abortion. When the Democrats filibustered the nomination of Neil Gorsuch, who was at the time seemed like a pretty down-the-line pick for a Republican president, that was about abortion. When the Republicans nuked the filibuster to get Neil Gorsuch through, that was about abortion. When President Trump, after the Republicans talking a lot about not having a just before an election nomination to the court, nominated Amy Coney Barrett on the eve of the election, very shortly after the death of Ruth Bader Ginsburg, that was about abortion. Obviously, there have been other aspects to the fiery debates we've had about confirmation hearings, but they've clearly played a central role. They've become deeply politicized compared to how they were, and that has shaped Senate and presidential elections. Every one of them has involved some talk about what kind of judges the senator would vote for. And probably the purest and clearest distillation of this kind of gravitational force of abortion on our national elections is the 2016 election itself, where a lot of observers on both sides of the aisle think that a but-for cause of President Trump's victory in the election was his releasing of a list of judges. If you went back to 1985 and told somebody that a future election, a presidential election, would turn on the fact that one of the candidates had released a list of judges he would nominate, you would have gotten a bewildered look. That is possible only in a world after Roe. So it polarized the issue, it moralized the judiciary, it politicized the judiciary, it made the judiciary central to our politics. It also, and I really struggled to find a snappy phrase that was parallel to the others for this fifth point, it juridified our politics. So by that I mean that it changed the way our political debates happen, which makes sense. The more our political debates entered the courtroom, the more our disputes about politics had to take the form that disputes in a courtroom take. In ordinary political debates, the general form is, I want this, you want that, let's draw the line somewhere in between so we get both our votes. In court, it's not like that. In court, the claim is, I have a legal right to win, and you don't. It's winner take all, and it's framed not in terms of general pros and cons, but in terms of rights that are trumps to whatever contrary argument you are making. It's been a commonplace of a lot of political theorists, Marianne Glendon at Harvard Law School, Alistair McIntyre at Notre Dame and elsewhere, to say that we have rights inflation in our country, that over and over our political debates devolve into just competing claims of absolute rights to beat the other side. I think a potentially underappreciated cause of that is the judicialization of our politics, is the fact that more and more of our political debates are occurring in the courtroom or are happening by proxy in court, which forces them to take the form of competing rights claims that brook no compromise. One possible example of this is the debate over same-sex marriage. So that began as a debate about practical pros and cons. The argument was that some people, look, gay men or gay women in these couples live together, they share their lot together, they share all the burdens and benefits of common life. It makes practical sense to allow them to have hospital visitation rights, to allow them to inherit each other's property upon death, to be medical proxies for each other. But very quickly, that paradigmatically political argument about pros and cons morphed into an absolutist legal argument, that there's a general legal right to marry, and that this is an integral part of that, so that there is no possible contrary claim about costs and benefits that could override the claim, because this is a rights claim, so it trumps. And notice that that in turn forced conservatives into competing rights claims. They couldn't simply say, well, look, if you look at the impact of the change in marriage law on our marriage politics and the way people understand marriage and operate within marriage, it might have this and that social cost. They switched to saying things like, well, same-sex marriage would undermine the right of children to be reared by a mother and father. Or they switched to a focus not on the immediate impact of different marriage policies, but on religious liberty, because religious liberty is a right. So it sounds like the kind of thing that can compete with a rights claim on the other side. That's the juridification of our political debates. Roe also judicialized our constitutional law, meaning it made the judiciary supreme, or it confirmed a pattern of making the judiciary supreme in constitutional interpretation. Now that might sound bizarre as a claim about an effect of Roe, or as a complaint, because it might seem like, of course, the role of the courts is to interpret the Constitution. And it is the role of the courts to interpret the Constitution. What's new, what arose in some cases in the 1950s but became cemented in Roe in the aftermath, is the idea that the courts are supreme when it comes to interpreting the Constitution. What could it mean to deny that? Well, take an example like Thomas Jefferson's. Jefferson was faced with the Alien and Sedition Acts, which basically made it illegal to criticize the government. He thought that was unconstitutional, that it was a violation of, the First Amendment, the right to freedom of speech. But the courts weren't stopping these convictions. So he exercised his independent power to interpret the Constitution by pardoning everyone who was convicted under the act because he thought the conviction was unconstitutional. And he said, if I don't do that, then we have delivered our government we have made the Constitution like wax in the hands of the judiciary to be twisted any way they want. So the judiciary had its power to interpret the Constitution in its domain when it came to specific cases and controversies, and the president has his own authority and duty to interpret the Constitution when exercising his powers, including the power to pardon. President Jackson was faced with a bill from Congress to renew the federal bank, the National Bank. And he said, I think the National Bank is unconstitutional. It exceeds Congress's lawmaking powers under Article 1, so I will veto it. Not just because I have a policy disagreement, but because I think it's unconstitutional. Certainly the most dramatic example of this departmentalism, as it's called, came with President Lincoln. In 1857, the Supreme Court in Dred Scott versus Sanford says that the Constitution makes the African descendants of slaves ineligible to be U.S. citizens and makes it impossible for Congress to regulate slavery in certain ways. President Lincoln said, well, that's you guys talking about what should happen within your domain, which is the resolution of cases and controversies between specific parties. So I will respect your decision as to the parties, including Mr. Scott. But when it comes to my own domain of running the executive, including by, for example, giving passports to U.S. citizens, I'm going to abide by my own judgment that the Constitution does allow the African descendants of slaves to be citizens. Today, almost nobody would do anything like that. The other branches of government, certainly states and so on, defer absolutely to whatever the Supreme Court says about the Constitution. And it's not just that they would never contradict the underlying logic of a Supreme Court opinion. They don't exercise an independent power of interpreting the Constitution at all. You will regularly hear lawmakers say, when asked about the potential constitutional problems with a bill, well, we'll pass it and let the courts decide. We'll let the courts figure it out. Sometimes as well, when a president is doing something that so far he has regarded as overreach, he will say, well, we'll do it and let the courts decide. That's again, an idea that was alien to our whole system of government until the 50s. It first came up when the Supreme Court asserted its supremacy in this context in superintending the effects of Brown v. Board of Education, the case that reintegrated the public school system. But it definitely grew and was cemented and supercharged with Roe. Those are the 6 possible effects of Roe. Here is the 7th. It's a general strain on our separation of powers. And in particular, the more that Congress gave up its policy-making authority to the policy-making by the courts, and the more it gave up another one of its duties, which is to check the executive by exercising its own judgment about constitutional limits and so on, the more that the power of the executive and the courts grew. I'll give you just one example of what this looks like when Congress abdicates its authority in this way in response to these developments of increasing the power in the judiciary and ceding policymaking and checking authority. It has to do with the administrative state. So a long-standing complaint of legal and political conservatives is that the administrative state, meaning the federal agencies that are supposed to enforce and fill in the regulatory details of our federal laws, agencies like the Environmental Protection Agency, the Department of Health and Human Services, and so on, have grown too powerful, that they have too much independence from the president on the one hand or from Congress on the other, that they're almost like a 4th branch of government that has these enormous powers to make regulations and to enforce them on pain of civil penalties that are effectively unchecked, that they go beyond constitutional power. There is a very simple fix within Congress's reach to do that. So anytime the conservatives have control of Congress and presumably the White House, they could, by federal statute, override or abrogate or shrink or entirely eliminate any agency overreach that they see. But there is almost no push to do that. What do they do instead? Instead, they focus on getting senators who will pick judges who will boost and supercharge long dormant doctrines, constitutional doctrines that would attempt to do that work for them. A doctrine called the non-delegation doctrine, which hasn't really done anything in about 70 years. It's only been used twice to strike down agency actions by the Supreme Court. And a bunch of other doctrines that would have courts more aggressively police agencies' interpretation of the statutes that they're enforcing, agencies' interpretation of their own regulations, and so on. Don McGahn, the White House counsel for President Trump, who picked most of the judges and justices that Trump appointed, said it was our main consideration when we were looking for Supreme Court nominees to pick somebody who would finally do something about the administrative state, even though Congress, in a second, as no one denies, could take care of whatever problems they think exist. So the strain on our separation of powers, the ceding of power away from Congress, expands the executive and the judiciary in different ways. Is there any hope of Dobbs undoing any of this? Well, obviously it's early days. It's only been 3 months since the decision, 5 months since the leak, 9 months since the oral argument where the court sort of signaled where it was going, 16 months or so since the court granted cert in the case, decided to take the case, which to some people already signaled where it might go. So it's too early to tell, especially for the 4th, 5th, 6th, and 7th of those effects, which are all quite downstream from the first few. So let me just say a word about the first 3 effects. The first one was the polarization of the abortion issue. Is that beginning to subside? I think there are limits to how much the issue can be depolarized, and I'll say something about that at the end. But I do think you see trends in that direction. So my own home state of Indiana, a very pro-life state, the Senate within the state came out with a law that had more generous exceptions than the law would have otherwise had. In Kansas, where the state Supreme Court in 2019 had said that there's a constitutional right to an abortion under our state constitution, so that even after Dobbs, Kansas lawmakers can't do anything about it, had a referendum for the people to decide just whether the lawmakers could do something about abortion themselves, or whether it was going to remain an issue for the state courts. And because of worries about the extremes to which pro-life lawmakers might take that regulation, the referendum failed. Governor Ron DeSantis, who wants to be president and who wants the nomination of the party that identifies as pro-life and anti-Roe, and that identifies as not supporting any exceptions except for the life of the mother, in Florida is only supporting a 15-week law. A law that, as I said at the beginning, is more liberal than the laws of almost every country in the world, presumably because he has some sense that in Florida or at large, a more aggressive law won't do. Blake Masters in Arizona, very conservative, very pro-life senator. As soon as Dobbs came down and he was moving out of the primaries and the talk turned toward what abortion regulations he would actually support, scrubbed his website of his very pro-life positions and said something about, I'd support a 15-week law. So you might be seeing some depolarization already. What about the unmoralizing of our constitutional law? Are we seeing a move away from nakedly moral reasoning by judges in constitutional cases? So Roe, as I mentioned, was not the first case to do that, but I think it cemented the pattern that had been emerging at the time. And I think you already see in this term, in the Dobbs term, a turn towards non-moral forms of legal reasoning. What does that look like? Well, in Dobbs itself, the court did not say we're overturning Roe, we're finding no constitutional right to an abortion, because actually the interest in fetal life outweighs the interest in getting an abortion. And they didn't say the opposite of that either. They said, when it comes to unwritten rights, we have all these cases saying that the test is history. The question to tie judges' hands to make sure they're not just doing their own policy preferences, is to ask whether a right was deemed to be deeply rooted in our nation's history and traditions. And when we look at history and tradition, we find it was not. So from the very dawn of the common law in the Middle Ages in England, all the way until 1960, not a single English case or state case or federal case or statute or legal treatise or law review article going out on a limb had ever suggested there was a right to an abortion. That on the contrary, abortion in almost all forms, except to save the mother's life, was massively regulated at all stages in every one of those Anglo-American jurisdictions for every one of those 800 years. And that basically persisted until roughly 1960, and that suggests to us there's no deeply rooted right. Therefore, if the other factors for overturning precedent are met, Roe has to go. In another case this term, another blockbuster case called Bruin, which involved gun rights, the court again looked to history. The lower courts, in enforcing the Second Amendment right to keep and bear arms, had adopted all kinds of moral balancing tests to figure out which gun regulations were constitutional or not. Almost every one of the lower courts, the lower intermediate courts, the circuit courts, had done that. The Supreme Court, in this one decision, wiped out all of those circuits' cases and said the test is history. The test is not whether you think or we think that the benefits of a gun regulation outweigh the costs. The test is whether this regulation has an analog in history. And so it looked at English history and colonial history. It looked at antebellum statutes and Reconstruction era statutes. It looked at late 19th century and early 20th century statutes. And it said, this particular gun regulation, which in that case was a New York law that required you to have a special need to carry before you get a license to carry, had no historical analogs. Therefore, it was out of bounds. You can agree or disagree with that test. It's interesting that that test puts the burden on the government to find a historical analog rather than putting the burden on the claimant to say that there's an analog to this rights claim. But whichever way you look at it, at least it is a step away from this kind of moralized reasoning. There was another blockbuster case called Bremerton, where the question was whether it was constitutional for a public school district to fire a coach who insisted on praying after football games at the 50-yard line. The district said it's definitely constitutional because it's actually required by the Constitution, because letting him do that is a violation of the Establishment Clause. It's like an establishment of religion. And their argument depended on a set of cases from the 70s, the same era that Roe came from, that said that the test for whether something is an establishment violation is whether the reasonable observer, weighing all the factors at issue, would think that it was an endorsement of religion. Well, that test was itself rooted in the test in the 70s that said you have to look to whether it had a secular purpose and whether the policy had the effect of inhibiting religion and whether it involved too much entanglement in religion. It was later glossed by the endorsement test. And the Supreme Court said, no, that is the wrong test to use. The right test to use is history. The question is, what was historically regarded as an establishment of religion? They said there are 6 different things, like funding of religion, funding of churches, of clergy, mandatory attendance at religious services, and so on. This wasn't one of those things, therefore it wasn't an Establishment Clause violation, and you cannot point to that as a justification for firing the guy. Okay, so the real test is whether this is actually going to stick. So there's a law professor at St. John's called Mark DiGirolamo who's written a piece called Traditionalism Ascendant, where he says this is actually a deep pattern that shows up not just in those 3 cases, but in free speech cases, Establishment Clause, Free Exercise Clause, Fourth Amendment law on searches and unreasonable searches and seizures, Sixth Amendment law on the right to a jury trial, even really mundane things like separation of powers questions like what counts as a recess of the Senate when it comes to recess appointments by the president, that in all these contexts, the court is increasingly looking to history rather than pure moral reasoning. The test, the ultimate test, the most immediate ultimate test of this is going to come this term when the court has a case about affirmative action. In the past, its affirmative action analyses have all ridden on a moral analysis. even the conservatives on the court have rested on a moral principle. Their principle is that the Equal Protection Clause requires each person to be treated as an individual, that's their moral right. And then the conservatives think affirmative action policies don't do that, and others think they do. There's a brief in the case filed by a bunch of historians, including some originalist historians like Evan Bernick, that says, you guys have never paid attention to history. You've just done pure moral philosophy in these cases. And if you look at the history, it turns out that affirmative action is constitutional. I haven't looked at the historical argument. I'm not an expert on it to say whether I agree with it or not. But the critical question will be, will the court squarely face that historical question, which it has never faced? And if it's really moving away from these moral reasonings in the constitutional cases and moving towards text, history, and precedent, presumably it will have to face the issue squarely. So there's some reason to think the issue is not as polarized or will not be as polarized as it has been, though there's limits to that I'll discuss. There is some reason to think the courts might be moving away from moral analysis or pure moral analysis and more towards historical analyses, looking at history and tradition. Is the court being depoliticized? Are we going to see an exit of political debates from the courtroom? It's obviously very early to tell. We can focus the question just by asking about abortion itself. So is there really hope of abortion staying out of the courts? And for the people who are skeptical that Dobbs is really going to undo any of the effects of Roe on our law and culture, most of them are skeptical because they think abortion is going to keep coming to the courts in some form or other. So is that the case? Well, there are some interesting trends to look at. First, so even in the lead up to Dobbs, when it became clear that the court was likely to be pretty supportive of abortion regulations, of states' power to regulate abortions, some of the leaders of the pro-choice movement, so the woman who argued Planned Parenthood v. Casey, the case that doubled down on Roe at the Supreme Court, and the woman who led the campaign to liberalize abortion laws in Ireland, co-authored a piece in The Atlantic saying, we need to give up on the courts as a means of protecting abortion rights. We need to move to the political sphere and conduct the battle there because it was always folly to rely on the courts. They're pointing this way today and that way tomorrow. Ian Millhiser, who's a journalist who covers the Supreme Court, and he's a commentator on legal issues. He's as progressive as they come, and progressives have generally made more use of the general principle that Roe relied on, substantive due process, the idea that there are unwritten rights that are rooted in the kinds of reasoning that Roe went on to engage in. And he said, I think substantive due process is a bad idea. We should stop talking about that because I don't want Sam Alito figuring out what unwritten rights he thinks exist in the Constitution and hamstringing the liberal states from enacting good progressive policies. You see Dan Epps, a professor at WashU Law School, saying things like, he's a very prominent commentator on the Supreme Court, saying things like, it's crazy for us to run a country based on vagaries and accidents of history, like when one of 9 lawyers in DC resigns or retires or dies. That it's crazy to have courts making these ultimate judgments as philosopher kings on behalf of the country. This is how conservative legal movement people talked for 40 years. And now we're hearing the similar kinds of disillusionment with courts doing politics on the left as well as the right. The most general and systematic evidence of this is widespread support for so-called court reforms. So packing the court in order to cancel out the political valence of the current court, or jurisdiction stripping, so the ability to take away from the Supreme Court the jurisdiction to hear certain kinds of cases, including abortion cases, which is an issue that has had supporters as varied as some eggheads in the legal academy all the way to AOC in Congress and everywhere in between. Proposals to put term limits on justices, and a wide range of other attempts to shrink the role of the courts and shrink their ability to do politics and to interfere in the political branch's business. Some say, well, whatever those progressive as well as conservative people might be saying, it's not going to happen because there are all these legal battles over abortion that are already on their way back to the courts. Like what? Well, there's a question about whether states' attempts to ban abortion drugs are preempted by the FDA's approval of those drugs, given that federal law is superior. There are questions about whether Mississippi can penalize people who travel out of state for an abortion, or who help people who travel out of state, or whether there's a constitutional right to interstate travel, well, there is such a right, whether that right overrides that kind of regulation. There are questions about whether federal statutes could preempt state abortion bans or impose their own abortion ban on the whole country. But notice a few things. First, now we have gone from the roaring river of sentiment about Roe, which has been dashed into 1,000 little streams about a lot of subsidiary questions. And they're subsidiary in two ways. One is that most of them don't go to the whole shebang. They're not about whether you're allowing or forbidding abortion tout court. They're about whether you can enact this or that ancillary form of regulation of abortion. So no matter how the courts resolve those issues, there will still be a wide range of play for states. Of course, that's not true of the federal laws. If the courts hold that Congress has the authority to ban or require access to abortion, then of course it's out of the state's hands. But notice the difference there is that even though it is comprehensive like Roe, it's not permanent like Roe. It can be reversed by the political branches after the next election. Even the one attempt to fully constitutionalize abortion in the other direction, which is the argument that's growing on the right, that actually not only does the Constitution allow states to ban abortion, it requires them to ban abortion, because the 14th Amendment, which guarantees each person the equal protection of the laws, covers the unborn, so that actually states are required to give the unborn the protection of the laws. Even that argument, which sounds like the most maximal way to take abortion out of the hands of the political branches, wouldn't really do that entirely. And the reason is that everybody, including the people in those debates on that side of the debate, would acknowledge that courts have no authority to require lawmakers to pass a law or to require prosecutors to enforce a law. And if they don't have that ability, then whatever they say about what the Constitution requires by way of protection for the unborn, they can't force that to happen. It has to happen at the end of the day by the political branches, who have the power to pass the laws and then to carry them out, to execute them, the executive. And in fact, the 14th Amendment itself in Section 5 gives Congress the primary authority to give effect to its commands, including the Equal Protection Clause. So there's some reason to think that even if abortion comes back in some form or other, it won't come back in the full force, full steam way that it did in Roe. If all of this is right, then you expect to see some downstream consequences that we don't have a full access to yet. So I have not yet heard a single candidate for the Senate arguing that they should be elected because they will make sure that we get back justices who will reverse Dobbs. It could happen. It could happen in a few years when the composition of the court looks like a closer call, but there is an open question about whether it will, or whether by that point all the steam will have been moved into the political process. We can ask the same thing about the presidential election in 2 years, whether we will have candidates on the left, by President Biden, Vice President Harris, whoever is the nominee, or if it's not one of them, one of the other potential candidates saying, I should win this election because I will make sure that Dobbs will go. We haven't heard it. If I'm right, there's a chance at least that we won't hear it because all the energy on both sides of the debate will have gone into the political process. But no matter what, you might say, look, all you've shown me so far in terms of depoliticization of the judiciary is that the courts have not, is that maybe abortion won't come back full steam. But that's just one issue. Well, I think, and this is what I'll end on, it may not be just one issue among others. It might be, for systematic reasons, the issue that has the most distorting effect in this way. So that to remove it from the judiciary is not just to remove one of many hot-button issues, but to remove the one that has exerted the most influence, and whose removal might therefore do some real undoing. What do I mean? Well, I said earlier that most political debates involve me saying I want this, you saying you want that, and then we draw a line somewhere in between. But there's one kind of policy that no one ever says that of, which is the policy of giving every person the protection of homicide laws. We disagree about who are persons. There's an obvious disagreement about that in the case of the unborn. But once you agree that so-and-so is a person, nobody, progressive, conservative, libertarian, would think that it's open to question whether you should withdraw the protection of homicide laws from that person. Because there will always be a contingent in the US that thinks that the unborn are persons, there will always be a group that thinks you cannot trade that protection against homicide with any other public or social good. There are deep burdens, serious burdens to unwanted pregnancies, and we have to find every permissible means to relieving those burdens, sharing them, shouldering them. But withdrawing the protection of homicide laws from a class of persons is not it. There's some reason to think that abortion bans actually began under this frame. So until about the 1820s, abortion at common law, under the judge-made law we inherited from England, was regulated massively from quickening onward. Before quickening, it was hard to know exactly what was going on, and there was some very outdated medieval biology that led people to think that there wasn't an individual human at that point. In 1820, the mammalian ovum was discovered, and with it, there were advances in the understanding of embryogenesis and the awareness that from conception onward, you have an individual organism of the human species. And when that was the understanding, the medical and legal treatises of the time across the board said, of course, protections against abortion should be expanded to begin at conception. So that by 1850, that began in 1828, but by 1858, half the states, by 1868, 3/4 of the states, by 1877, all but 2 of the states, soon after that, all of them, and all of them, or almost all of them until 1959 or so, had done that. And there was not a single argument. It was seen as a matter of right, and there was not a single contrary rights claim. There was no academic or other literature arguing that there was a right to an abortion. Of course, now there is. In the 1950s, the anovulent birth control pill was invented and approved. Its use gave people the ability to separate sex from procreation, which in turn gave rise to a demand to be able to separate sex from procreation even when contraception fails. And that's when you begin to see people make the bodily integrity arguments that first show up in the literature around that time. Today, then, we do have a pitch battle of rights claim against rights claim, but because that battle itself could be rooted in the belief that there's a right to life, which once you think there's a person you can't compromise on, there will be some limit to the degree to which compromise on this is possible and depolarization is possible. But conversely, if that's the issue we have taken out of the courts, at least at full steam, then there's at least some hope that the effects of bringing that issue into the courts will begin to be undone. Thank you for your patience. So I'm happy to take questions until Professor Watson tells me to stop. Yes, Jordan.
Thank you. Could you comment on the significance of the Dobbs leak as a precedent? What the consequences of that might be?
Yeah, so I don't have like sort of sappy piety towards the court. I worked there for a year. I have no attachment to it now. But I felt gut punched when that happened. I thought it was astonishing. And I thought that it was something that nobody that I know that has ever clerked would even have it on the table as an option. It's not that we all did the calculus and thought it wasn't worth it or that it was wrong, all things considered. It just wasn't a live option. So the fact that it has been done now makes it a live option in a way that it hasn't been before. And that, I think, is really bad for the court's internal process. So the court, even though they all constantly brag about how collegial they are, and it's more surprising than you would think. So it was very standard policy that you never circulate an opinion first to your friends, the people you expect to vote with you. You circulate it to the whole court. That if you have a disagreement with the opinion you want to tweak before you join it, you don't circulate a memo to your friend, you circulate it to the whole court. All the court's deliberations happen in a way that's accessible to everybody. The clerks on each case talk to each of the other clerks on that case. So I would always talk to the Ginsburg clerk, the Sotomayor clerk, and so on. The justices conducted almost all their communications through their clerks. So go find out, what the Breyer clerk says about where Breyer is leaning on this or that. I think all of those things are going to be harder to pull off going forward. There will be silos, or at least a temptation to form silos. Maybe on the humdrum, boring cases, there won't be a big change, but on the others, there will be suspicion. There will be a little bit less freedom of movement, which will hurt the deliberations of the court and presumably the work product's quality. But it remains to be seen. Yes?
So you mentioned when you're talking about the gun control, gun rights case, that they looked for historical analogs for modern day laws, right?
Yes.
How do you make that analogy from historical to today?
That's a great question, and it's the million-dollar question about this case and whether this version of a history and tradition test will be viable. So what the court says is, well, look, okay, you can't find exact analogs, but you can find proper analogs. And a proper analog is a policy deeply rooted in history that had the same trade-off of cost and benefit as a current policy. So that starts to look like it's reintroducing the moral balancing that they were supposedly getting away from. And there's an exchange between the majority and the dissent on exactly that question. But the court is saying, no, it's not the judge herself or himself doing the moral math, figuring out, do I think these benefits outweigh these costs? The judge is asking, did people back then think this trade-off was justified? Can we find an analogous law that imposed this much burden on the ability to keep and bear arms for the sake of this much benefit? That's the comparison that's supposed to be made. The fact is that the record, there isn't a ton of regulation to go off of. So whether this test is really viable in the long run will depend on how easily, but also in how disciplined a fashion, courts are able to make that comparison. Yes?
You mentioned about Congress, for instance, and the executive branch being able to interpret the Constitution and exert its right. But, you mentioned about the fourth branch. There's the other fourth branch, the media, and which exerts a large influence on the political side of things. And so you said, again, you wouldn't really see that today, and it seems in some ways because it's constantly trumpeted. Look at the lawlessness of the executive branch or the legislative branch. They're trying to introduce politics into this, where this is kind of the pristine sort of logical approach to the law that we ought to approach.
Yeah.
So you had someone like Roy Moore on the, when he was governor, or a judge, state Supreme Court. I think he became governor when he was saying states have a right to, the federal Supreme Court can say this, but that doesn't mean we have to do it, because we have the right to interpret the Constitution too. We have the right to interpret our state law. And you had Andrew Jackson, what the Supreme Court said when they made the Indian Removal Act. You're going to do it this way, and he said, well, they made their decision, let them enforce it, but I'm going to do this. You can't get away with that today because the media, for instance, pilloried on Roy Moore and said, that's ridiculous to think that you can have an opinion different than the Supreme Court. How would you even get around something like that in today's culture?
Good. So there's a bunch of distinctions to draw. So one thing is, there's a question about whether you should defer to a court order when it exists. And most departmentalists, most people who support the idea that the other branches have their own authority and duty to interpret the Constitution think when push comes to shove, in the sense that when the court is operating within its own domain and it issues an order governing resolving a dispute between particular parties, the other branches do have to respect that order. So if the judiciary is doing its job, you respect the work product that it has the authority to produce. So then the question is just, do you have to follow its underlying logic for that order across the board, even in cases where you're just handling your own domain and they're not interfering, like the issuance of passports to US citizens under Lincoln? And there, I think even most departmentalists would say, look, most of the time in practice you should defer because no need for unnecessary conflict and because things are more stable and coordinated that way. But when the stakes are really high and you have a serious disagreement, you should act on your disagreement. So if a court approves a law, but you still think it's unconstitutional, you have the authority and indeed the duty, since you yourself took an oath to the Constitution, to veto the law if you're in a position to do that, or to pardon people convicted under it if you're in a position to do that, etc. So let's suppose that you have a really sympathetic case, the kind of case that departmentalists would say you should exercise your independent law interpreting authority in. There, I think the remedy is some education. Almost everybody thinks that the idea of judicial supremacy goes all the way back to the founding. But Alexander Hamilton spoke against it. Jefferson, Jackson spoke against it. John Marshall, the fourth Supreme Court Chief Justice and Chief Justice of the United States, very highly regarded. Everybody thinks he said the opposite, but he didn't. So there's a need for education, both in what the founders said and in those important episodes where the stakes were so high on the consistency with the official powers of the court was there, that the other actors were justified in doing it. And Lincoln is obviously the most salient example of that, but not the only example. Without that kind of civics education, an education about how new the idea of judicial supremacy is, basically Cooper versus Aaron, a case from the 50s, I don't think you can overcome that kind of opposition. Yes?
Yeah, you talked about how Roe didn't actually mention much of the Constitution or any in the actual opinion from it. I was wondering if you could make a case for the dissenting opinion from the Dobbs decision. Why? I mean, you laid out in this lots of reasons why it should be overturned. Is there a case tied to the Constitution for why Roe
Good.
should still be?
Great. So to clarify a few things. So Roe itself said, well, some think that there's a right rooted to privacy, which is the right they relied on, rooted in the Ninth Amendment or other parts of the Bill of Rights. Some would say the Due Process Clause. We feel that it's the Due Process Clause, but what's crucial is that wherever it's found, the right to privacy requires X. In the course of that, at no point did they quote any of the relevant provisions. So what I was saying is that they don't, and the details of what they come up with, the viability rule and so on, are not rooted, not even claimed to be rooted in the text. So what is the best counterargument? The dissent in Dobbs, for the most part, relies on what is a straightforwardly legal argument, which is precedent. That's an argument Roe could not rely on because there was no precedent before Roe. So that is an available argument. It's the one where the Dobbs opinion puts the most emphasis. Dobbs says, in terms of disagreeing with the history that I recited, that at all stages, from the dawn of the common law until 1960, not a single legal source or commentator or anybody had suggested there was a right to abort. They don't disagree with that. They don't disagree with the claim that from the 1828, 58, 68, 77, so on, states started expanding criminal penalties for abortion to apply from conception. They say the court shouldn't be fixated on 1868, the year that the 14th Amendment was ratified. There's nothing special about that. They should look at the full sweep of our history. But the court answers, well, we did look at the full sweep, and it turns out that until Roe, basically, even the year that Roe was decided, 30 of the states banned abortion from conception, and all 50 of the states had laws that were inconsistent with Roe's new rule. So they don't make a ton of that. They do say at one point, well, at least at common law, early abortions were not criminal. So there's some kind of hint of resonance with Roe's rule that later abortions you can ban, but early not. But then the majority says, well, actually, even those at common law, when they weren't technically criminal, they were still unlawful. They were still subject to all kinds of legal burdens. If you performed if you wrote a contract to procure an early abortion, that contract was void for illegality. If you advertised abortions, that was unlawful. If you were engaging in performing even a very early abortion and someone died, however accidentally in the process, you were guilty of murder, even though normally murder requires intent to kill, because abortion was treated like a felony. And that's the one case, if you're robbing or kidnapping or something, that's the one case where if somebody dies, we're going to hold you on the hook for murder without intent to kill, just because what you were doing was so unlawful to begin with. So the court says that. So the main emphasis of the Dobbs opinion is on precedent. But But if we bracket that, because you could go either way on that. Nobody thinks precedent is sacrosanct, that it should never be overturned, and the Dobbs dissent says it shouldn't always be sacrosanct. And nobody thinks it should mean nothing, right? So exactly where you fall, exactly when you think it should be overturned, depends on a lot of complex factors. Nobody has a very clear and clean theory of it. The dissent gives you its reasons, the majority gives you its reasons, in the second half of its opinion. I recommend both of them to you. They're careful analyses. Is there a better argument? My theory is that the Dobbs dissent did not give a new argument because it did not want to give an argument for the majority to slap down and make more precedent rejecting abortion arguments. So best they could do was stick to the arguments made in Roe and Casey, and then hope for a day when the better arguments can be aired, and they can then say, well, the court didn't reject those. But what are those arguments? I think the best argument that's been made, the one that's gotten the most influence among academics, because there's been a cottage industry. So when Roe came down, some of the leading liberal constitutional scholars of the generation, the most important two, John Hart Ely and Larry Tribe, said that we support abortion access as a policy matter, and Roe was bunk. John Hart Ely said, Roe was bad constitutional law because it was not constitutional law and gave almost no sense of an obligation to try to be. That's a direct quote. Tribe said, behind Roe's verbal smokescreen, the basis for its judgment is nowhere to be found. And he said one has to reread the opinion to make sure that nothing has been inadvertently left out. So they were savage in their criticisms of its reasoning, even though they liked its outcome, which meant that for 50 years there was a cottage industry among academics to try to find a new basis to ground its result. And what was the convergence? The convergence was on, well, some people said it's the 13th Amendment, the amendment that bans slavery, because abortion, forcing a woman to carry a child to term, has relevant analogies to slavery. That was not a popular argument, though it is made. The most popular argument by far was an equal protection argument. The idea is that to guarantee women the equal protection of the laws, and in particular to guarantee them equal access to social and economic opportunities, without forcing them to give up something that men aren't forced to give up, which is sexual autonomy, you have to have abortion access. If you don't, they're forced to choose between at least risking their opportunities to join the marketplace in the public square or curbing their sexual autonomy. That's a burden that they face that men don't face. That's an equal protection problem. I think that even though that argument is supposed to improve on the argument in Roe, it actually shares with Roe the weakest premise of Roe. So the weakest premise of Roe was the idea that somehow the Constitution, the Due Process Clause, imposes on all the states a view about fetal moral worth, a view about the point at which the fetus gets to count enough that you can ban its killing. And that was the thing that Ely and Tribe and all these others said the court has no argument for. But I think that's a tacit presupposition of even the equal protection argument. In order, just to give you one example, in order to show that the states that ban abortion are accepting a burden on women that they would never accept on men, you have to find a context where they are lifting a burden from men at the cost of withdrawing the protection of homicide laws from a class of persons, or something morally comparable to it. If you can't find that, and if you want to leave open the possibility that they're allowed to see the unborn as persons, then you haven't actually shown an asymmetry yet. So you need an independent argument that they're not allowed to see. It's unconstitutional in itself for them to regard the unborn as persons before you can say, you can open up the possibility that the Equal Protection Clause requires to the withdrawal of the homicide laws from them for the sake of social and economic opportunities and autonomy for women. Okay,
Yeah.
thank you very much.
Thank you for coming. If you are, perhaps your interest is piqued, I encourage you to talk to Professor Wester about the pre-law program. The pre-law program in the Henry Institute will be doing more programming this year. We're delighted that Professor Gerges made the trip up. Thank you for coming, and we hope to see you again at another event. Professor Wester, anything to add?
I don't think so, but thank you all for coming.